Hello and welcome to Legally Speaking with me, Tarun Nangia. And the topic we choose today is very interesting. It is in the backdrop of the government mulling over decision on what skill-based games should be taxed at. A group of ministers, which has seen the participation of Meghalaya Chief Minister Conrad Sangma. He is currently sitting over this issue. And of course, it will go before the GST Council in the month of September. But we want to understand what this whole issue involving taxation for all these games that you play on your mobile, also on your computers, should they be taxed at 28%? Or what is this whole issue all about, and why is the industry having a certain view on the government, and where is the middle ground? What is the appropriate taxation that will ensure the industry grows, jobs are generated, as also the government gets its fair share of revenue, somewhere the middle path, which is. I have a very, very eminent panel who will discuss this issue with me. May I introduce you, Senior Advocate Rohan Shah. He's a leading counsel at the Supreme Court India and the Bombay High Court. I have with me Sameer Chuk. He's Chief Legal Officer of Games 24x7, which is a skill-based gaming company. Mr. Chuk joins Legally Speaking with Tarun Nangia for the first time. So I would want to also share that he's a vast experience both on the law firm side, where he's been senior partner with eminent law firms, and now also on the general counsel side, where he's worked in various companies. Good to see you, Mr. Chuk, and looking forward to some interesting input from you. I have with me Vaibhav Kakkar. He's partner with Saraf and Partners, one of India's leading and fastest growing law firms. And at the outset, may I go to Senior Advocate Rohan Shah for his opening comment before I move on to Sameer for a detailed view on the sector. Mr. Rohan Shah, over to you.
Thank you. So I think, as we look at this issue, there are really three issues wrapped into one. I think one issue is really about the nature of the industry, the velocity of the industry, and the sort of investments it attracts and the sort of results that it can create for any economy. The second is really the issue of the GST, which is the specific issue that we are discussing. And within the GST, I would think there are two issues. One is the formation of policy, and where the GST Council as the statutory and constitutional body to look after policy formation, the view that they will take. And third is what is going to be the viewpoint of courts should the matter ultimately have to be resolved by courts. Now, the core controversy is really twofold. One, currently, the industry is being taxed at 18% of GST, and it is being taxed on a gross gaming revenue, which is really the revenue which is left with the company for the services that it renders. What is being debated is whether the rate should go to 28% and whether the valuation should be done on a basis of the totality of the amounts which have been received by one of the service providers at a point in time, right? And the situation really is you also have three diverse types of activities, because what is being looked at is horse racing, what is being looked at is casinos, and what is being looked at is online gaming. And I think it's slightly unfair to sort of try and paint all of these in the same brush, because commercially they are not the same, right? And the situation therefore is, at one level, you have what is essentially going to be a policy initiative at the GST Council. At the same time, this issue is effectively pending before the Supreme Court. And the one issue that the Supreme Court has dealt with earlier and even more currently, namely, when you have this nature of activities, are they just gambling, or is there an element of skill? And if there is an element of skill, then the situation is that takes it out of the realm of gambling. And if that is what effectively happens, then you ought not to treat this either from the perspective of policy formulation or from the perspective of classification as gambling. And the moment you sort of address that issue of whether it is gambling or not, I think, the rest of the issues flow. So I think one is the challenge at the policy level. The other is the challenge before the courts. And I think, as background goes, I'm sure we've set some background and we can now sort of bring in all our other participants.
Thank you, Mr. Rohan Shah, for your introductory explanation on a broad overview of this issue. Now, for a detailed dive, I'll go to Sameer Chugh, he's Chief Legal Officer, Games 24/7. Mr. Chugh, look at any mass transportation in India, metros, buses, people are into their mobiles. They need some sort of thing to pass time. Gaming has really caught on in this country. People interact, people engage with each other. It is a form where you generate friendships when you play against your friends. So, in a sense, you are also a social network, so to say, because you become a platform for people to play against each other, interact with each other. Now, when so many people are interested in this kind of a platform or commodity which companies like you offer, the government has a certain view on it vis-a-vis taxation. You are in the thick of it. So I want to know from you, there is user demand, there is great potential. How can interests be balanced? What kind of taxation do you think the government can consider, and what would be your submission? And secondly, if the industry grows, the taxation amounts will grow in leaps and bounds. If millions of crores of people are using, why not? Can you take us through this whole issue?
Sure. Thank you, Tarun, for having me on the show. And it's great to be in the company of Rohan and Vaibhav here. See, I'll tell you the biggest concern from an industry perspective. Rohan aptly put it that we are really talking about a differentiation between game of skill and game of chance. I think the first parameter there is to ensure that we don't treat game of skill as something which is gambling and betting. And I think that's a very clear legal situation which is already there, and it's legally, aptly clear. I don't think this is debatable, but I do believe that, some parts of, the authorities do turn around and take a slightly different view. And albeit that's probably because they're a bit confused or whatever, but I think that's a very clear position that online skill-based games, which are predominantly based on skill, are not gambling and betting. Now, if that is the case, I think it's also important to see it from an industry perspective and an overall perspective, that what is the online skill gaming industry? Now, if you look at the online skill gaming industry today, see, it has certain, functions, or rather, I'll tell you, it has certain parts to it which fit into the government's vision as well. Now, in fact, if you hear, Honorable Prime Minister Modi's statement, he's very clear. He wants India to be a gaming superpower. Now, I think that is where the start point has to be from the authorities' side. That if India has to be a gaming superpower, you have to help it grow. You can't kill it today, or you can't put either, whether it's taxation or regulations, which turn around and stop the industry from growing. If you look at it today, some small numbers, let me share with you. There are 20 crore plus gamers in India, today, if you look at it, there is approximately an FDI investment of about 20,000 crores, which is US $2.7 billion into the gaming industry. Then there are, about more than 500 startups, which are already there in the gaming side. I mean, look at us. We are already a unicorn. We have valued about $2.5 billion. If you look at the annual revenue, it's approximately about 15,000 crores. And the annual GST contribution today is circa 2,200 to 2,300 crores. Now, that is already a huge amount which is being contributed by the industry for an industry which is not really, still grown fully. I mean, there is a lot of potential out there. So important from a government perspective to ensure that there is a more balanced situation. So anything, whether it is a GST charge, there are two parts to it. One obviously is the rate, and second is really if you see what is it charged on. If you look at the rate today, we're sitting at 18%. I gave you the GST numbers already at an 18%. This is what is the contribution. If you look at it globally, the best practices internationally are ranging between 15 to 20% as the GST on online skill gaming. Now, clearly, it is important for the government to turn around and look at it in the perspective of where the growth is. This has to be one of the big pillars of actually turning and contributing to the $1 trillion economy, right? And digitization, gaming superpower, you can only become if you are turning around and actually having either the GST rate and the GST levy, as well as regulations which turn around and actually help to turn around and grow this industry. So therefore, today, already at an 18%, and that's on the gross gaming revenue. I'll talk about the gross gaming revenue as well, is a huge contributor to the exchequer. It'll only bound to grow. As per our numbers, in about 2025, we see this 2,300 crores to go to approximately about 6,000 crores. So or maybe a little more. So that's the kind of growth you are seeing. Now, if you turn around and then say, I'm going to now levy GST on not the gross gaming revenue, but on the whole deposit, you are killing the industry. What you're really doing is you are turning around and then forcing people to move into, the gray side of the black market, or whatever you want to term it as. Essentially, there'll be illegal operators who are sitting offshore. People will move there. And therefore, not only will you kill the industry, not only will you hamper the growth, you will also hamper the contribution into the exchequer. Therefore, the larger question to me, is really the GST on what? And to me, the GST on what has to be the gross gaming revenue, because that is what we earn. That is what is a taxable service. And I think Rohan can probably, add to this later, and so can Vaibhav. But the GST nexus has to be directly to what you would call as a service. And in this case, our service is only the platform, and the platform fee is what is the gross gaming revenue. Therefore, taxing it on the entire entry fee or the deposit is itself not correct.
Thank you. Thank you so much for explaining this in a certain amount of detail. And thank you for all those facts and figures you share with us, which give us an insight into what kind of numbers you're talking of and the potential of taxation close to $1 billion, according to you, by 2025. I'll go across to Vaibhav Kakkar, partner with Saraf and Partners. Do you think the government is also seeing reason in the arguments which are made by these gaming companies? A. Secondly, though revenues in terms of taxes are important, how do you arrive at a balance, Vaibhav, where both interests are managed? The government realizes its revenue. The people get the benefit of these services, which they are hugely liking and using. I think you just have to look around you to see how many people are playing these games. Could you share these things with us?
Thanks, Tarun. Thanks for having me over. It's always a pleasure. I couldn't agree more with what Mr. Shah and Samir have said. To be honest with you, I wonder where is the confusion. If the government is looking at what the regulatory and the legal framework is insofar as taxability of these matters of games of skill and games of chances, and if they look at what the jurisprudence Supreme Court has been laying down since 1950s, I think the path would be rather quite clear. Right from the days of RMDC Chamar Bagwala as a constitutional bench judgment in the Supreme Court in 1950s, straight leading up to Satyanarayan judgment, which of the Supreme Court in late 60s, which said that rummy is a game of skill, to a judgment of Lakshmanan in the Supreme Court in 1990s on the issue of horse racing, straight leading up to 3 High Court judgments in the last 1 year, namely Karnataka, Tamil Nadu, as well as Kerala. All of these judgments have decisively ruled that when there is a particular game of skill involved, the rules of gambling and the rules of lottery and the rules of betting should not be applicable. To further break this down, and while we have Mr. Shah and Samir, who will very eruditely also explain some of these nuances. But if you look at the central GST law, what it states is that insofar as any actionable claim that does not involve matters of betting, gambling, or lottery, they would not be considered as a supply of a service or a supply of a good. And therefore, there would be no levy insofar as such actionable claims is concerned. For the benefit of audience, by actionable claims, what you mean is any claim that someone may have on a certain amount of money. So, for instance, if you, me, and the other 2 guests all participate in a particular game, and all of us contribute 50 rupees each, then those 200 rupees become a sum which could essentially be seen as a deposit, as Samir was explaining, or rather an actionable claim that each of us may have until the game is played, and the outcome of which one determines who's the winner. Now, the CGST law is rather quite clear that any actionable claim other than matters of betting, gambling, and lottery would not be regarded as a supply of a service or a supply of a good. Now, the real question here is that when you look at real money games of skill, and with this rich jurisprudence that the Supreme Court has laid down since 1950s and constitutional bench decisions at that every game has skill involved and chance involved. But where those games, where skill outweighs chance, they would be regarded as games of skill. They will be constitutionally protected under Article 19(1)(g), have each company and each individual, each citizen having the right and the freedom to undertake that business and profession. And with that being the jurisprudence, any restriction that you apply upon them have to be reasonable in nature. And to add to that, the entry betting and gambling under entry 34 in the state list, under which each state has the power to legislate and ban games of chance, very clearly has to be interpreted. The words betting and gambling have to be interpreted conjunctively. And the word betting by itself has no meaning or significance. The word betting has to be only and only interpreted when it is read with the word gambling. So there is no such thing as betting on games of skill. I believe the pressure on the exchequer to try and extract revenue and lack of understanding that the word betting, when it is used, has to always and always be read along with the term gambling is where I think the confusion has arisen. There are 3 High Court judgments, Tarun, where the company, where various gaming companies have gone and challenged any actions taken by the state governments to ban those businesses. And in each one of those judgments, ultimately, each High Court has conclusively held. And of course, a couple of matters have now gone up to the Supreme Court, but there is no stay insofar as the High Court judgments which have struck down those laws, very clearly ruling that the word betting and gambling really means games of chance. And games of skill are at a different footing. Now, when you look at this jurisprudence and you look at the central GST law, which very clearly states actionable claims other than betting and gambling and lottery are not to be considered as a supplier for good or service. I think you add those 2 principles put together, it's very clear that real money skill-based gaming industry cannot be painted with the same brush as gambling or as games of chance. And really, whatever revenue that the platform is making is on what taxation should be applicable. And you cannot be throwing the baby out of the bathwater. You have to allow the industry to grow. You have to allow the businesses to flourish and grow the pie. And that's how the tax revenue will go.
Thanks for sharing this detailed explanation with us on this issue. I'll go to Senior Advocate Rohan Shah. Mr. Shah, I want to understand from you these 2 points. A, how does the government arrive at a decision on this? Because there is a certain view in every quarter as to how this thing has to be looked at. Some people will look at it from the sociological perspective. Other people will give other, because this all also has the element of politics involved in it. Of course, it's in India, anything can't be divorced from politics, so to speak. I want to understand from you this, that now this GST Council is looking after this issue. I have got a very interesting input which Samir Chugh gave, which said that people will simply move to other jurisdictions beyond the ambit of the Indian tax authorities and start offering services. Do you think if you push too much, the industry simply runs away? How does the government avoid that?
So, let's squarely take on the issue of what would this be regarded as under GST, okay? And let's apply first principles which are intrinsic to GST and leave aside for the moment where we are applying the first principles. So the number 1 first principle is you tax on the basis of the true commercial nature of a transaction. That's Playworld Electronics, that's from 1989. What's the true nature of this transaction? When somebody comes to participate, that somebody knows that they will contribute a sum of money. Everybody's contribution will become a pool of money, and the winner or the set of winners will have the ability to take away the winnings from the pool, and only a certain amount will be left with the platform, which is effectively hosting or conducting this. Okay? If this is the true commercial nature, 2 things come in. In the period that the company in question holds the money, it actually holds it in a fiduciary capacity. The company has no ability to appropriate this. It has to hold it in a capacity of trust. Now, why is that capacity of trust? Because whoever wins effectively will have a claim, and that claim effectively has to be answered. So issue one is whoever participates knows this is the structure. What you hold is in a fiduciary capacity, and he who wins has a right of recovery. This answers the most basic issues in terms of saying that A, it's an actionable claim, B, all you're doing is acting in a fiduciary capacity, and what you momentarily or temporarily get in a fiduciary capacity is never consideration, and that we have to correlate everything to the true nature of the transaction. This is principle one. Principle two, does every flow of money from a participant to a service provider become value which is taxable? You have the Marmagua Port judgment, you have the British Gas judgment, which says every flow of money between a participant and a service provider is not consideration which is taxable. Only that which is consideration for service rendered can be taxed. Everything else has to be ignored. Now, in a different stream, whether it's in the oil and gas industry, whether it's in infrastructure, this principle has been upheld. So does this principle now have to be modified for this industry? The answer is no. Now, if these two fundamental principles are taken, the answer is absolutely apparent, that the value can only be the value attributable to service, amounts held in a fiduciary capacity, or which will be subject to actionable claims, cannot be taxed. So this is the valuation part, which is a big part of the puzzle. The second situation is, what rate will you apply? Now, one situation where we will do ourselves a disservice is that if Supreme Court repeatedly says that this is skill and not chance, the worst thing we will do is to treat this as a sin industry. Because if we attach the wrong label, we will have the wrong attitude. So you can't treat this as sin goods or sin services. This is skill-based. Let's correlate in real life to other skills. Surgical skills, lawyering skills. Are we going to say that anyone who effectively exercises skill for a return, which to a common man is not decipherable as being appropriate, is somebody who will now look at a 28% rate? Nobody is going to say that. So if it is skill, then what do you have as the rate structure for skill-based professional services or professional participation? Would be one view. And obviously, you would have a much more moderated, benign rate of tax. But let's look at the other situation where you have huge turnovers which have to be subjected to tax. What have we done? And let's take two examples. Let's look at the gem and jewelry industry, and let us look at real estate. The moment you have large quantums of turnover that you're looking at, in gem and jewelry, our rate is 3%. In real estate, we have a proportionation basis where we exclude land, where we exclude construction, and we come to a fractional approach of what we want to tax. So if we are able to put what is learning available today, namely how we look at value based on Supreme Court, and forget this industry, forget the other debate about, gaming, skill, gambling, that remains where it is. But if we took the normal law as it is, applied it to this industry, both for value and rate, it is inevitable that we will emerge with a far more livable structure. And that structure will clarify what the value should be. And that structure will also push more for a moderated, benign rate than an extremely high rate. And then we don't have to engage with all of this to say, will investment migrate, will opportunity migrate, will tax migrate? So I think the answers are there. They are really on the wall. The point is, who's going to shine a light on them?
Thanks for that wonderful explanation, which helped us all understand the whole issue. We're almost out of time, so I will just quickly go to Sameer Chok for if he has any input to make before we move on. Sameer, you're not audible.
Sorry, apologies. So no, absolutely. What Rohan said is aptly correct. See, the only additional points that I would make here is, remember and see exactly the light that Rohan mentioned is that, what do I get? I am a service provider. I'm providing service. All I get is a small percentage of that. Just to, so therefore, That is what is the taxable service. That is what should be taxed at. Rate, rightly said, is something that's a different conversation. But having said that, I did also quote that internationally best practices are between 15 to 20%. You're already sitting at 18%. I mean, ideally, I don't see why the rate should change. I mean, that's already giving you good revenue. And rightly, as it was said, that if you increase the pie, the share increases. That's exactly the way that this happens.
So now we'll take the last two comments. One very quick comment from Mr. Vaibhav Kakkar and Mr. Rohan Shah to close the show with his final comment.
Thanks, Tarun. I completely agree with what Samir and Mr. Shah had said. Just two quick observations. I think one, what is very important to understand is the fact that the state governments have been making these attempts to look and paint skill-based games as games of chance. That hasn't worked as yet. My apprehension is that if the central government and ultimately the GST Council does not receive this point rather quite well and is not able to make this differentiation, you will again be back in courts. And eventually you will see some sort of a positive decision because there is established jurisprudence. But the problem that will happen, Tarun, is that, as Samir has mentioned, $3 billion of foreign investment has come and we are counting and more would come. Each time you create disruptions like these, which are ultimately not legally sustainable, it creates a lot of unrest with foreign investors. They think we are a banana republic where legal jurisprudence keeps changing every now and then. And that's not good for anyone. So I think, therefore, it's imperative that the government looks at the settled jurisprudence on the subject and then makes an intelligible differential between the two. And the second quick point is that the RBI has a very, very defined legal framework on payments. And as Mr. Shah was explaining, each time an individual gamer deposits money to participate and puts money towards the rake, all of the gaming companies, follow very detailed guidelines on escrow and things like those to make sure that those monies are not played around with. So ultimately, what the gaming company is only enjoying is its platform fee. All of the other money is taken away over with the winner. Now, with those facts, to be looking at taxing the entire pool, I think apart from just not being legally tenable, would be farcical as well. I think those are the two quick points.
Thanks for that. So we'll go now for the closing comment to Mr. Shah. You for the closing comment, Mr. Shah.
Yeah, Tarun, I think, ultimately as a nation, the number one thing we need right now is congruence and credibility. If we are aspiring to be the fifth largest economy in the world, if the vision of our Prime Minister is that we should be the gaming capital of the world, then quite clearly decision makers on the tax side must act in a manner which gives congruence and credibility both to our ambition and our vision. And I think this is a good opportunity to do that.
Thanks so much for that comprehensive, detailed analysis of the issue that you shared with us. I would like to thank Senior Advocate Rohan Shah, Samir Chugh from Games 24/7 and from Saraf and Partners, Vaibhav Kakkar, who all joined us. We will revisit this issue with all of you closer to the GST Council date, when this all will be very hotly debated from various sides, and we'll also get a sense of what is going to happen, because states will also realize that what it is in it for them, and the central government also has a keen eye on what revenues they can make without disturbing the industry, which will spoil the whole prospect of getting any taxation from it. Thank you so much. Thank you so much for joining us.
Thank you.
Thank you. Thank you very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.